In my last video, I mentioned that Tesco lost the benefit of its £1 million marketing spend because it used the Clubcard name instead of a stronger name like Tesco Card. If you missed it, be sure to watch those videos. Although Tesco received an inadequate service from its advisors, chances are that at the time, Tesco didn't realise it received a poor service. That's why many advisors in the branding industry get away with delivering a poor service to their clients. Unless people understand brand IP principles, they don't realise what a weak name looks like, or that it could cause their business to be less successful or to fail even. It doesn't surprise me that even the likes of Tesco receive an inadequate service, because there is a widespread tendency in the branding industry to opt for descriptive names. Such names are either not ownable, or even if they are just distinctive enough to register, they're likely to be weak and difficult to enforce against copyists. That's the drawback with some descriptive names. Many business owners assume that names that describe what their business does is the way to go, so they regard the legal rules that prevent them from trademarking descriptive names as a hurdle to be overcome, rather than as an indication that they should reconsider their choice. People don't consider the brand protection aspect of names, and hence don't realise that using a weak name adversely impacts their revenues. That's because such names are impossible or too difficult to enforce against copyists. I've known of businesses spend vast sums of money to fight passing off cases over generic or weak names that they should never have chosen in the first place. Instead of wasting money litigating, they should draw a line under the matter and find a stronger name. I'm appalled that some lawyers actually encourage their clients to fight these cases that are obviously going to be a losing battle. My initial reaction was to question the ethics of such lawyers, but then when I thought about it, I realised that these lawyers are probably fighting these cases because they themselves don't understand the subtleties of names. Just as the general population and many professionals in the branding industry don't consider the brand protection dimension when choosing names, so lawyers too, who haven't been trained in brand IP, won't necessarily understand names either. Just because someone is a lawyer doesn't mean they magically understand specialist topics like brand IP. Unless a lawyer specialises in brands and trademarks, they're unlikely to recognise what constitutes a good name. That's why my brand tuned program is suitable for commercial lawyers as well as for designers, marketers, founders, or business leaders. It gives them the skills needed to identify whether a name or other sign is suitable for a business's individual circumstances and needs. Brand IP is a term I use to distinguish it from what people normally associate with IP, namely patents, science, engineering, and complex technologies. There is a widespread myth that IP is only relevant to a business once it's successful and has something to protect. But contrary to such beliefs, brand IP is about IP issues that need to be addressed early on from the outset when developing a brand. It impacts business design and branding. Brand IP is about understanding that brand protection is as much about the choices you make as it is about the actions you take to protect what you've already chosen.